Hello and welcome everyone to this FATF webinar on extended confiscation. My name is Katie Simpson and I'm with the FATF Secretariat. I'm also joined by my colleague Mary Beth Grunstra, who is also with the Secretariat and handles our work related to asset recovery, including the 2023 standards changes and the forthcoming FATF asset recovery guidance and best practices. We're pleased to welcome representatives from jurisdictions across the FATF Global Network and other interested parties who have joined us today online. So before we start, I just want to share some housekeeping information for everyone. This is a public webinar. It's open to everyone. It will be recorded and published on the FATF's YouTube channel and our training academy for delegates. So don't worry if you have colleagues who couldn't make it today. They'll be able to view it later. Thank you to everyone who already submitted questions in advance of the webinar along with their registration information. You'll also notice there is a Q&A button at the bottom of the Zoom display. This is where you can post questions during the webinar to our panelists. I can't promise we'll get through all of the questions today, but we will try and answer as many as possible at the conclusion of the presentations. We're also happy to let you know that French interpretation is available today. You can choose to listen to the webinar in French through the interpretation button at the bottom of the Zoom screen.
Thank you very much, Katie. Good morning, good afternoon, good evening to everyone who's tuned in for this FATF webinar. Just for a little bit of background to those who are new to these discussions, this is the second webinar in a series of events that the FATF is putting on post-updating the FATF standards in late 2023 on asset recovery and related international cooperation. The point of this webinar series is to support jurisdictions in implementing and understanding the revised FATF standards on asset recovery, and also to help actually increase the effectiveness of asset recovery around the world today. The FATF revised its recommendations, as I mentioned, in 2023, and this provides a much more robust toolkit to countries in the fight against criminal assets. And it also underscores the priority at the policy and operational level, both domestically and internationally, that countries should be placing on asset recovery as a very important component of an AML CFT system. So essentially, evaluations that have been carried out around the global network, so all of the FATF members plus 200 countries around the world, have shown that there are persistently poor results when it comes to confiscations and asset recovery, depriving criminals of their ill-gotten gains. This is in spite of trillions that are actually generated in the illicit economy. And one conservative estimate is that countries are only confiscating around 2% of criminal proceeds that are in the economy. So to this end, some of the relevant changes to the FATF recommendations relate to more provisional measures and to tools to help intervene earlier in the crime and stop transactions and secure and restrain assets. However, today we're going to discuss a phase that comes a little bit later, and that will be the final confiscation phase. So the FATF standards, which is recommendation 4 for those who are familiar, require countries to have a comprehensive range of confiscation measures that allow them to finally deprive criminals of the proceeds, instrumentalities, and corresponding value associated with crime. Whichever measure a country uses in any particular case will be up to them. But at a minimum, countries are required to have conviction-based confiscation, non-conviction-based confiscation, and now extended confiscation. So today we will focus on extended confiscation. So this is a very new requirement in the FATF standards. It did not previously exist. Some jurisdictions have had extended confiscation for a very long time and have achieved really good results in this. This is one of the reasons that the FATF took note of it as a good and innovative practice and wanted to basically spread its use throughout the global network. For other countries, this is a very new concept and a new power, or it doesn't yet exist in their national legislation. So one of the goals of today's webinar is to answer the question, what is extended confiscation? If you've tuned in for that reason, you've come to the right place today. We have about a little more than an hour with you to discuss this with a very good panel. However, just in simple terms, maybe we can start by giving a quick definition that the FATF uses. So extended confiscation is a form of criminal confiscation which allows a court to extend the reach of confiscation to additional property of the defendant that is not specifically related to the offense of conviction. So the interpretive note, which is the part of the FATF standards that explains the very short recommendation, has a little bit to say about this and about the details. So basically, it requires that to the extent that such a requirement is consistent with fundamental principles of domestic law, countries should have measures, including legislative measures, which enable confiscation to be extended to other property of a convicted person when that person is convicted of money laundering, terrorist financing, or predicate offenses, and where the court is satisfied that such property is derived from criminal conduct. The FATF standard elaborates a little further and says, in determining whether the property in question is derived from criminal conduct, this could include, for example, whether the value of the property represents the proceeds of a criminal lifestyle of the defendant, or is disproportionate to the known lawful income of the convicted person. The final sort of caveat here is that countries may limit extended confiscation to those predicate offenses which are considered serious in their system. And of course, by predicate offense, I mean the crime that is underlying the money laundering, regardless of whether or not money laundering is charged in the case. So just the normal crime that generates the criminal proceeds.
Thanks, Mary Beth, for that great introduction. I'm sure we'll get into the nitty-gritty and real details of that over the course of the next hour or so. As Mary Beth said, today our purpose is to demystify extended confiscation and hopefully increase its uptake as one tool of many which can help to really take the profit out of crime. The aim of this webinar is to support countries in enacting and implementing extended confiscation effectively and in a way that protects the fundamental rights of criminal defendants. So without further ado, I would like to introduce you to our expert panel today. So firstly, we have Professor Elżbieta Hryniewicz-Lach, Chair of Criminal Law at the Faculty of Law and Administration of Adam Mickiewicz University in Poznan, Poland. We have Andrew Kerrigan, a specialist prosecutor in the Proceeds of Crime Division of the Crown Prosecution Service of England and Wales. And finally, we have Judge Edward Gabriel Levi, the Chief of Service for Legal Representation at ANABI, the National Agency for the Management of Seized Assets in Romania. So thank you to all of our expert panelists for being here today and sharing your expertise on this important subject. So firstly, we want to bring in Professor Hryniewicz-Lach. Ella, can you help us begin to demystify extended confiscation? Namely, what is extended confiscation and what is it not?
Well, thank you for inviting me to be here with you, and I try my best. So extended confiscation is a certain type of confiscation of unexplained wealth that refers to assets that go beyond those linked to the offense of conviction. However, it is necessary that the court has a reason to believe that they are proceeds of crime. So the prosecution is usually required to first show certain proofs or facts, which may activate preset legal conditions or presumptions. And then the confiscation may be extended at the discretion of the court if the defendant does not rebut the evidence with their own. So it's the prosecution that will first present the evidence, for example, that the defendant did not have or cannot show that they had the financial resources justifying the acquisition of certain property. And then the defendant will try to remove some or all of the assets from the scope of extended confiscation by showing that the assets have a plausible and legal origin, which means that we need some assets at stake. And for that reason, extended confiscation relates basically to habitual offenders, serious offenses, organized crime, and other individuals who are believed to have accumulated illicit wealth due to their criminal lifestyle or pattern of offending. Well, so I can give you the example. Just imagine that we have a prosecutor that put forth the evidence for a concrete crime of drug dealing, and that results in a finding of guilt for the so-called predicate offense. But in the confiscation part of the case, we need something additional. So the prosecutor delivers the initial evidence of the defendant's previous involvement in some other, maybe similar activity, and points at the disproportion between the defendant's legitimate sources of income and the defendant's valuable assets, may also indicate the unusual manner in which a certain specified property has been stored or acquired and concealed, like a big amount of money, of cash found in the apartment, and that defendant tries to provide a reasonable explanation for it, which can be, for example, that they inherited the money from the members of the family, or that the money comes from very profitable car sale. But sometimes the defendant does not provide for any relevant documents for a claims and does not even remember in the concrete case who the buyer was or what were the other details of the sale. And then the court may come to conclusions that it is not convinced that the concrete assets come from are of legal origin, so come from some legal source. When I think about what extended confiscation is not, then I think about non-conviction-based confiscation or civil asset recovery, because extended confiscation requires conviction for a predicate offense for money laundering, for example, and then the court should be satisfied on the basis of the circumstances of the case, of the submitted evidence, that the assets at stake are criminal in origin. So extended confiscation is this normally part of a criminal case, occurring after it, related to it. Yeah, so that's basically what I think on the issue.
Thanks, Ella. I think you raised some really interesting points there, particularly about the charges. So as folks on this webinar will know, prosecutors generally bring charges for the most serious, readily provable offense or offenses in the case. But sometimes this may only be one crime, even though over the investigation, the law enforcement and prosecutor have actually found evidence that the person committed many different crimes over the course of time, and that they may possess property that is derived from these other offenses. Sometimes there are obstacles to bringing those additional charges. Sometimes the statute of limitations has run out. Sometimes the evidence just might not be as strong, and you don't want to jeopardize the case. There's various reasons, but it seems like extended confiscation could then be useful in a situation where the authorities could only charge certain offenses, but it seems that the defendant is sitting on criminal proceeds from perhaps a string of prior and uncharged crimes. Does that sound kind of appropriate to you?
I would even say that's the point, because you can imagine some lifelong criminals or major players in organized criminal groups or other individuals that have accumulated substantial wealth over time through the crime that was undetected or uncharged due to practical difficulties in prosecuting it often, maybe because the crime were committed and the asset accumulated under different jurisdictions. And these individuals are rather the police officers for years, but it's impossible to find them or impossible to prosecute them for every single case, as giving the examples of where it may be difficult or for some reason not applied. So if we have the predicate offense and a good reason to believe that individuals have benefited financially for a variety of criminal activity, then we can apply that kind of powerful tool to recover the proceeds of crime, in particular from those who have committed serious grave offenses and for that reason had a chance to accumulate criminal wealth over time. But at the same time, we should always remember to respect the defendant's rights, the defendant's fundamental legal safeguards, as well as the legal safeguards of the affected third parties.
Yeah, thanks, Ella. That's a good point. And it kind of reminds me of the idea of the Al Capone strategy, right? Which is, we knew that Al Capone, the famous gangster, infamous gangster, had committed a ton of different offenses, but it was hard to nail him down on one. And in the end, you charged a tax crime. So if only extended confiscation existed when Al Capone was around, we might have gotten a hold of many more of his assets. I think one other point to raise is what happens if there is an acquittal in the criminal case. So there's a finding of not guilty, no offense of conviction. What happens then? How would this affect the confiscation part?
So already mentioned, we need some kind of predicate offense where the conviction for it opens the door for extended confiscation. So if we don't find guilt, we won't have conviction, and without conviction, there will be no confiscation that could be extended to other assets. But what is important to show is that there's more than one example of extended confiscation regime. It's more than one example how extended confiscation looks like. So sometime you may require, or some laws required explicitly, the disproportionality of relevant assets to the defendant's lawful income. Others accept that the court decides on the basis of other warning signs, like the previous link of the affected person to criminal activity, certain untypical storage of valuable assets, not registering the property when it is required. Some countries accept the lower standard of proof in the regards. On the prosecutor side, sometimes accepted is the legal presumption of illicit origin of assets, or shifting the burden of proof at some point from the prosecutor to the defendant. Accepted are different kind of assumptions or interferences that create certain kind of legal shortcut. It's like saying when these conditions are met, it is usually that a case has no legitimate explanation in what refers to the assets. So it's most probably that the assets are of illicit origin. But the defendant always has to have a chance to contest the operation of any interference and proof of the contrary, because there always can be certain kind of perfectly legitimate explanation of the assets. But you should remember in each case that extended confiscation is not a general confiscation. So it's a criminal sanction, and therefore it should be sufficiently specific. The defendant must know which of their assets are eligible for confiscation and for what reason.
Very strong point, Professor. I think it's important to reiterate that extended confiscation is not general confiscation. It is not confiscation of all the assets owned by the defendant without cause. In fact, the property to which the confiscation is extended, it should be shown that there is some link to criminal conduct, or, as you mentioned, one of these inferences or assumptions or presumptions might operate, and then switch the burden to the defendant to actually show, no, there's a legitimate origin here.
Exactly. The prosecution should make some showing that the assets are derived from some other earlier offenses or from a certain pattern of conduct, and that there's likely no other legitimate source of origin for the assets aside from a crime. It may be done by showing some financial evidence, like the income and expenditures, net worth calculations, or even tracing evidence if it is possible.
Yeah, that's very good. And I think, we've kind of covered all the reasons why extended confiscation might be a very useful tool, targeting these career criminals, these habitual offenders who've engaged in a pattern of crime over the year. But perhaps we should discuss with you, what are some of the common misconceptions of extended confiscation for those who might not be so familiar with it?
Well, there's a common misconception that once you are given such a new, powerful, but still a new tool, it can be used in all possible cases. It's kind of accepted and you can use it wherever you want. But as mentioned, the extended confiscation is a powerful tool, and we don't want to use the cannon to kill a mosquito. So basically, the extended confiscation should be reserved for career criminals who have engaged in serious criminality. It can affect, so the extended confiscation in practice, the right to privacy, right to property. It may create certain tension with fair trial, in particular with the rights of defense. And for that reason, the proportionality requirement will justify its application only to the cases triggered by serious criminal offense, when the evidence gathered in a case and disclosed to the defendant speaks convincingly of the illicit origin. Besides, the extended confiscation in particular case should be worthwhile, because it can result in a litigation and process, in a lot of work for the prosecutor. So it should refer to significant assets, so that the efforts of the prosecutor will result with confiscation of relevant, valuable assets. The prosecutors should therefore decide or be able to decide in a case whether to apply that kind of instrument or not. Should either use the conditions set out in law, their internal procedures, or prosecutorial discretion to decide whether to pursue extended confiscation. It should only be pursued if the facts warrant it and the law supports it. So it should be nothing that works automatically with criminal charge or even with conviction for certain kind of crime. And another check of power is always the court or the judge or the jury, who still have to decide if the requirements of extended confiscation are met in specific case. So that's not only the prosecutor that should hold the power.
That's a really great explanation, Ella. I think the expression about you not using a cannon to kill a mosquito is a very apt one. And you're right. There's different checks on that power. Can you speak about not all extended confiscation has a reversed burden of proof, but some of the systems do. Can you speak a little bit about that and whether somehow it prejudices the defendant, that they're not presumed to be innocent, or that they have to speak first and defend themselves before the prosecution has said anything?
Yes, in fact, there are 2 points that I would like to mention in regarding to what you just said. So first of all, there's certain kind of misconception that extended confiscation always requires the reverse burden of proof, and even in totality. In fact, some legal systems like Romania or Germany would not accept the legal presumption of illicit origin of defendant's asset, which reverse the burden of proof from the beginning, from the prosecutor to the defendant. And others accept that kind of instrument. However, it is important that the initial burden of allegation is always on the prosecutors. Due to the basic legal safeguards in fair criminal proceeding, the right to information, the right to defense, the right to remain silent without negative consequences, the burden of proving the origin of defendant's asset cannot be shifted automatically to a defendant without previous disclosing to them which of their assets are eligible for confiscation and for what reason. So the initial burden of allegation goes always with the authorities, with the prosecutor. But it's worth mentioning, once again, that the legal presumption of illicit origin of defendant assets is not required, and it does not work in every case of extended confiscation as applied by different legal systems. And one more thing comes to my mind that refers to what you mentioned, is the concept that it is kind of a punishment, and for that reason it's incompliant with the presumption of innocence. So extended confiscation is not a punishment. It does not punish people. It targets the assets in order to guarantee that crime does not pay. So it's not a punishment in the sense of a repressive, punitive reaction to illicit behavior. It can be classified, and is traditionally or formally classified sometimes as a part of the instruments of penalty, of prevention. However, according to common understanding, confiscation, asset confiscation, including extended confiscation, has a restorative aim. So it should deprive one of assets that come from crime. It's a kind of response to unjust enrichment that should help the authorities to sort out incorrect property ownership. So it's not a punishment, but an instrument of restorative character.
Ella, that's fantastic. And I think you're exactly right about the purpose being to revert to the status quo before the person used their offending to obtain property that they should not have had and was not theirs to begin with. I think we'll probably have to cut it there. We could probably go on for a very long time with you. It's almost as if you've written a book on extended confiscation that the audience may be willing to check out in their free time. I think just very quickly, we want to mention a topic that came up a lot when this concept was introduced into the FATF standards, and that is how can it be compatible with fundamental principles of domestic law? So FPDL for short, so we don't have to say it every time. But what are these? These are essentially the very core values or the deeply entrenched legal norms that animate a country's legal system, and they can be found in constitutions or in high court decisions, and they are very, as you can see, they are very weighty concepts. So this slide mentions the right to remain silent, the presumption of innocence, the right to a fair trial, proportionality, and non-arbitrariness. So countries do not have to implement extended confiscation in a set way. There is flexibility in the FATF standards for countries to design a system that works under their law and their regime, and also accommodates these fundamental principles in different ways. And I think we just want to highlight a couple of key notions. So a recognized good practice in this area is for the law on extended confiscation to be very specific, very detailed, and very clear. This helps increase predictability both for the defendant as to what could be in scope of a confiscation, but also for the practitioners and for the courts. And there is some level of educating the judiciary in the use of any new tool like this. So it's a great idea if a country's law or rules can set out very specifically what are the procedures, what are the inferences or presumptions, if any, are used, and more importantly, what is the process that will be followed to respect the rights of the defendant and also of third parties who may claim to own some of these assets to which confiscation is extended. I will just briefly plug the FATF's upcoming asset recovery guidance and best practices. That should be adopted at our plenary in 2 weeks, and we hope to have it published in November. This guidance has an entire chapter on extended confiscation, including some of the bells and whistles that countries can use to protect these fundamental principles of domestic law. These are very nitty-gritty procedural things that I won't get into today, but essentially, like they speak to the nature of the process, disclosing the evidence that's relied upon, especially any financial calculations, and having a fair and meaningful shot for the defendant to make the case and rebut the initial showing of the prosecutor. So I think we've talked a lot about extended confiscation in theory, but now we want to turn to the practice. And we are lucky to have 2 officials from 2 countries with very different legal traditions. We have the United Kingdom, which of course is a common law system and has had extended confiscation for a while. And also we have Romania, which is a civil law system. So you can compare and contrast and see how this might apply in your own jurisdiction at home. So without further ado, I would like to turn to Andrew Kerrigan, Specialist Prosecutor with the CPS. And thank you, Andrew, very much much for being with us today.
Thank you. So yeah, I'm a specialist prosecutor in the Proceeds of Crime Division of the Crown Prosecution Service in England and Wales. And I've been asked to share my experience of extended confiscation in criminal proceedings. Our confiscation process is set out in the Proceeds of Crime Act 2002, which we refer to as POCA. It's Section 6 of POCA. It requires consideration of extended confiscation in every confiscation case. The prosecutor's initial statement explains if a case is subject to extended confiscation and on what basis. So how do we determine if a case is to be subject to extended confiscation? Section 75 of POCA sets out 3 scenarios in which extended confiscation will apply. The first scenario applies if the defendant is convicted of a serious offence included in a list at Schedule 2 of POCA. Schedule 2 includes offences such as drug-related offending, money laundering, slavery, arms trafficking, sexual exploitation. The second scenario applies if a defendant has engaged in a course of criminal conduct and has benefited by £5,000 or more. There are 2 options in the course of criminal conduct scenario. Firstly, if in the current proceedings, the defendant is convicted and has benefited from 4 or more separate offences. But if this option is not relevant, we can look to the second option, which applies if the defendant has at least 2 separate previous convictions for offences for which he has benefited within a period of 6 years, ending with the day on which he was charged with the current offences. The course of conduct scenarios enables extended confiscation in less serious offences where there is evidence of habitual offending, such as in cases of thefts and frauds. The third scenario is where a defendant is convicted of an offence committed over a period of at least 6 months, and the defendant has benefited from the conduct by at least £5,000. This again enables extended confiscation to be applied to less serious offences. The intention of Section 75 is to provide a safeguard to limit the application of extended confiscation. Currently, if a case falls under one of the above scenarios, the prosecutor has no discretion and must proceed with an extended confiscation. There are proposals before our Westminster Parliament which, if passed, may give the prosecutor a degree of discretion. So how do we determine the benefit in an extended confiscation case? In the initial statement, the prosecutor firstly sets out details of benefit the defendant obtained from the criminal conduct for which he has just been convicted. We refer to this element as benefit from particular criminal conduct. The prosecution has a higher burden of proof in respect to this element of the benefit, and the benefit calculation will refer to evidence from the prosecution. The second part of the benefit calculation relates to the extended confiscation, in which we apply an assumption model. So in POCA, the assumptions are referred to as lifestyle assumptions. The criminal lifestyle scheme is intended to capture and legally define the type of defendants who are career criminals. All that the prosecutor needs to prove on balance of probabilities is that the defendant has obtained a benefit. We do not need to prove that the benefit was derived from specific criminal conduct or even a particular category of criminal conduct. The burden of proof then switches to the defendant, who must rebut the assumptions and show a legitimate source of funds on the balance of probabilities. The assumptions can be summarised as the transfer assumption, property held assumption, and expenditure assumption. The transfer assumption relates to any transfer of value to the defendant within the relevant period up to the date of the conviction. The relevant period commences 6 years before the date the defendant was charged with offences. Generally, the most common transfer assumptions will look at unexplained credits to defendants' personal and sometimes business bank accounts. The defendant may provide clear and cogent evidence to explain that some of the transfers are from legitimate non-criminal sources. But we normally find that for a proportion, even a significant proportion of transfers, defendants are unable to rebut the assumptions. Defendants may be self-employed and explain that transfers relate to self-employment income. But where the defendant has failed to disclose income to the tax authorities or has a cash-based business, the defendant again will often struggle to rebut the assumption. The next assumption is property held after the date of conviction. The assets of greatest value, namely houses and apartments, often fall into this assumption, even if they've been held for decades, and consequently, this assumption is often contentious. The final assumption is expenditure. This is a useful assumption and can capture benefit that may otherwise be missed. An example that I've encountered on multiple occasions is following a search of a property at the arrest stage. The police may find evidence of ownership of jewellery, such as empty Rolex boxes, receipts, and certificates of authenticity, but fail to locate the actual jewellery. In those circumstances, the benefit can be captured under the expenditure assumption, which is especially useful if the expenditure was cash-based and not recorded elsewhere. It should be noted that in many cases, following a financial investigation, and notwithstanding that the extended confiscation regime applies, there may be no evidence of transfers, property held, or expenditure, in which case the benefit is based solely on the particular criminal conduct for which the defendant was convicted. So what safeguards are in place? Well, Section 17(6) of POCA states that if the defendant accepts he has benefit from criminal conduct in his written responses, that acceptance is not admissible in other proceedings. It is not possible in future confiscation proceedings to revisit the period prior to the date of a confiscation order in which the extended confiscation provisions were used. There is the 6-year limitation on the second course of conduct scenario relating to previous convictions and for the transfer and expenditure assumptions. There is the £5,000 limit on the course of conduct and prolonged period of offending gateways. And we have Section 10 of POCA, which states that the assumption should not be applied if the assumption is shown to be incorrect, or there would be a serious risk of injustice if the assumption were made. And finally, the court must state its reasons if applying one or more of the assumptions. Given the far-reaching nature of extended confiscation procedure in England and Wales, it has been subject to numerous challenges, most recently in the European Court of Human Rights, in the cases of Bagnall against UK, Sharma against UK, and Colley against UK. Each raised a number of points, but they all included the same submissions on the statutory assumptions. They all made submissions that the assumptions were incompatible with Article 6.2 of the Convention. It was argued that the assumptions were equivalent to new charges, and therefore were contrary to the Article 6.2 presumption of innocence. The court considered numerous previous decisions on the meaning of a charge in criminal proceedings and determined that the application of the assumptions was not analogous to a new charge and therefore did not breach the Article 6.2 presumption of innocence. The case of Colley in particular also argued that the confiscation process was incompatible with Article 6.1, right to a fair trial, and Article 6.2, on the basis that the right against self-incrimination, which exists in relation to the defendant's written submissions, does not extend to comments made in oral evidence. It was determined that the process that we have is compatible with the ECHR, as there was no element of compulsion to give evidence. There was an express protection in respect of written submissions, and in this case, he had in fact given dishonest written submissions and had given evidence. But he made a further submission in respect of Article 6.1 in relation to the fairness of the assumptions. And in the judgment, the court specifically highlighted the safeguards within POCA, which they say ensure fairness. So I'm finally just going to touch on two case examples. My first case followed a conviction for production of drugs and used property held assumptions. This was an extended confiscation case because the defendant was convicted of an offence listed at Schedule 2 of POCA. The benefit from conviction was 2.3 million, but the defendant was found to hold a large property portfolio and cryptocurrency, none of which he could legitimately explain. The value was therefore added to the benefit, increasing the benefit from 2.3 million to 12.7 million, which resulted in a confiscation order of 9.8 million. And the slide shows a picture of the machine that was used in the production of drugs. The second example relates to a series of targeted burglaries, which included targeting a well-known musician and professional footballer. This defendant was convicted along with two co-defendants. It was an assumptions case because the offending took place over a period of more than 6 months and the benefit was more than £5,000. The pictures on the slide shows one of the defendants breaking into a property and images of stolen items retrieved from one of the defendant's phones. This defendant was convicted of conspiracy to commit burglary and conspiracy to handle stolen goods. The particular benefit in this case arising from the charges was just under £314,000. The assumptions, which included transfers of £35,000 and a house and other items under the property held assumption, which totaled £237,000, gave a total benefit of just over £586,000, and the available amount, which included equity in a house, seized cash, restrained bank balances, and other items seized, totaled £249,000. Thank you.
Thanks so much, Andrew. That's so interesting for us, and I'm sure for the audience as well, to hear the experience of a country that has such a long history with extended confiscation, and particularly enjoying the picture of the person trying to break into a house there as well. That's great. So we'll move on to our second country experience. So Romania introduced its extended confiscation regime in 2012, and since then has made changes to strengthen the tool while maintaining important safeguards. So I'll hand over now to Judge Edward Levy to share Romania's experience with introducing extended confiscation.
Thank you very much. I want to say that I'm a civil judge and I'm seconded in National Agency of the Management of Seized Assets, which in Romania is both Asset Recovery Office and Asset Management Office. So in this capacity, I deal with all the legal aspects related to the administration and interlocutory sales of the assets, including the management of the complex assets and the implementation of asset sharing agreements at the national level. So even if I'm a civil judge, in this matter of confiscation, we have both areas, the civil area and the criminal law aspects. So about history of Romanian experience in the extended confiscation, I want to say we have this model of confiscation since 2012 through the Law 63, which transposed the Council Framework Decision 212 from 2005. At that stage, the mechanism was strictly limited because it applied only for the offenses explicitly listed to the legislator, such as corruption, drug trafficking, or organized crime. It was 21 offenses in total, so a long list, but it was a list. And this list was in the old criminal law, criminal code, which was a communist criminal code from 1969. In 2000, and criminal code, Article 112, the same restrictive approach with a list. So the real turning point came in 2020 with the law 2028, which fundamentally changed the system. The list of offenses was removed and a new general criterion was introduced. Any offenses punishable by at least 4 years of imprisonment can now trigger extended confiscation. So this reform was brought the Romanian framework much closer to the European standards and to the functional spirit of the Directive 42 from 2014. So before 2022, the extended confiscation could be ordered only for a narrow and predefined group of offenses. This means that even if the criminal activity produced major unlawful profits, the measure could not apply unless the offense appeared in that list. So the list was linked to the offense and also to the criminal activity. So if you didn't have these two linked to the list, you cannot apply extend confiscation. After 2020, the perspective changed. There is no longer a list, but general threshold, as I said, at least 4 years of imprisonment. The effect with the significant expansion of the scope, which now covers a much broader range of crimes from complex economic offenses. For example, we can apply now extend confiscation to the abuse, office abuse, which were not applied before 2020. The advantages of removing the list, which are in the next slide, the elimination of the list has produced several key advantages. First, it facilitates the evidentiary process. Previously, prosecutors have to prove that the profit came from activity linked to an offense appearing in the list. Now, it is sufficient to show that the assets derive from criminal activities, regardless of the specific legal classification. Second, it gives court greater flexibility and predictability to the third parties and to participants, because the rule no longer depends on the future amendments of how the legal qualification might be changed. Even if the classification evolves in the courtroom, because there are new proofs for the predicate offense, the measure remains applicable as long as the 4-year threshold is met. So also for us, for judges, is a normative simplification, because a single coherent rule replaces a complex enumeration of the total 21 offenses. Ultimately, the reform strengthens both justice and practically obstacles, ensuring that the crime should never pay. Of course, it was a new vision in 2020 also about the third parties, which they are very often involved in this mechanism, because the preparator, they are not own the goods on the real name of their real name. They often hold the assets under the family or other persons. So we established that in 2020, we established that extent confiscation may also target asset transfer to the third parties, but only if those persons knew or should have known that the transfer aimed to avoid confiscation. And also we needed to recognize some safeguards for the third parties. They need to be formally summoned in the courtroom, and they are allowed to participate in hearings, including via video conference, to present their defense. They also enjoy a right of appeal, meaning they can challenge the confiscation order before a higher court. Finally, the law protects bona fide third parties. Assets obtained for consideration and in good faith cannot be confiscated, and it will be extend confiscated from the person which is convicted in equivalent. So it will be a confiscation, but we protect the third party, and we will equivalent execute the confiscation, extend confiscation order from the person which is convicted. So these safeguards ensure that the principle of proportionality and the protection of the legitimate ownership for all the participants. We had a very important moment after the introducing of the extent confiscation with a ruling of Constitutional Court about non-retroactivity and non-retroactivity of this instrument. So the Constitutional Court ruled that extent confiscation cannot operate retroactively. It applies only to assets acquired after the introduction of this legal institution, that is after 2012 under the old criminal code and 2014 under the new criminal code. This is based on the principle of no-retroactivity, which is at Article 15 in the Romanian Constitutional Court. And it's express of the right of the property, which is also under the Constitution and the European Court practice. So we have some practical obstacles in this matter in the international cooperation, and I can present you a study about that. It was a extent confiscation order from a court from Paris, which needed to be recognized by a court from Romania. And the court of Romania reject this file because they consider that the assets, they are not owned by both before 2012. So the house was owned from 2005, something like this. And the court considered that the Constitutional Court ruling is prior to the Regulation 1805, which is the international cooperation instrument between France and Romania. So I saw a question at some point about the new directive, and yes, indeed, for us it is a main activity to look forward at Article 16 of the new directive, which provides a new form of extent confiscation of unexplained wealth. And we put a problem about what to recognize again the effect of non-retroactivity ruling of the Constitutional Court also for this new type of confiscation.
Thanks so much, Edward. That was really interesting, especially to hear about the evolution of the system in Romania, and also you touched on some of the challenges that I'm sure other countries can also relate to. So I just wanted to say a huge thanks to all of our presenters today. That's the end of our presentations. This has been really eye-opening for us, and I'm sure for the audience too, to get these varied perspectives on extended confiscation. So we have had a lot of questions come in from the audience, both through the registration process and also submitted through the Zoom chat. So thank you to all of you for your active participation in this. Hopefully some of the questions were answered over the course of the webinar, but we did pick up on a few that we wanted to throw to our panelists and see if we can get some answers for you. So I'll start with a question that a few of you might want to respond to, so feel free to jump in. It's quite practical. So how do you ensure that prosecutors and judges are trained and confident in using extended confiscation effectively? If there's a lack of familiarity with the tool or how it works, how do you promote its use in appropriate cases? So I'll open the floor to our panelists if someone wants to jump in on that. Go ahead, Edward.
So thank you. At the national level, we have the National Institute of Magistracy, which is a body, central body, which periodically organize courses and seminars, and all of us, all the magistrates, judges and prosecutors are obliged to participate at least 3 of these activities in each year. So naturally, those related to the criminal law often address issues concerning extended confiscation, and we talk a lot about that. And also we have another instrument. All the judges and prosecutors can access a database, an electronic database with all the courts sentences. So with some main words as extend confiscation, we can identify a lot of sentences there, and we can take it and improve our judgment.
That's great. I'll throw it to Andrew as well. I think he had something to provide input on this answer as well.
Yeah, I mean, in England and Wales, the Crown Prosecution Service is centralised its confiscation to one division in the CPS, and that happened during COVID, and that obviously has the advantage that we can centralise training, we can react quickly to developments in the law, and I touched upon the proposals that are currently before Parliament, which may implement some discretion for prosecutors, and we'll see how that develops. But if that is passed, then we will see training and guidance, and it can be very quickly put in place for the prosecutors within the division, all of whom are specialise in confiscation.
Yeah, thanks, Andrew, and thanks also to Edward. I think you make some very salient points about the need for specialization in this area. So asset recovery in general is quite a nuanced area, and when we get down into extended confiscation, I think as much as we try and expand its use, it's still quite a niche practice. So practitioners are always looking for examples. I think probably the European Court of Human Rights cases would also be instructive, and the training efforts towards judges and prosecutors is really key. In your experiences in cases, what have been the key legal or operational challenges in actually using this in your cases, in your experience? So, for instance, like, have you found difficulties with invoking the assumptions, or proving the disproportion of wealth, or tracing assets, or anything like that? And what would some solutions be to these sort of common issues that arise in cases?
Yeah, I can come in on that first if you wish. So, I mean, one of the issues that we have is that we, in order to use the assumptions, we need to show, first of all, on the balance of probabilities, for example, for using the transfer assumptions, that those transfers have taken place, or for using property held assumptions, that the defendant actually holds property. And we encounter the usual issues, but I think one of the questions from the audience was about sort of international aspects, and obviously we still, if the assets are held abroad, we still have that requirement on balance to show that they hold, say, an apartment abroad, or that they have a bank account and there are transactions within that bank account. So we've got the usual challenges, with international letters of request, in order to be able to get that evidence. And yeah, I mean, and we have similar challenges that everybody has, in terms of crypto assets. But obviously, we're seeing some developments in technology there, which are helping us, to trace that assets and sort of make some progress in that area.
Thanks, Andrew. Maybe a little follow-up to that is, do you have to have all the evidence gathered during the prosecution phase, during the case in chief on the merits, or is it possible for you to get more evidence in the confiscation proceeding later if there's something missing that the prosecutors need?
Yeah, so it depends on a case-by-case basis. In some cases, there'll be a financial investigation, which will have commenced at a very early stage. We'll have restraints, and we'll have a lot of that information once it comes to confiscation. But yes, in other instances, the financial investigation may obtain further evidence after the conviction. Yeah.
That's very helpful. And maybe we'll turn to Edward for some insights on this.
So in addition to what Andrew mentioned, I will also highlight several legal challenges, since in the matter of confiscation, numerous civil legal relationships may arise when the third parties are involved. Therefore, I would add that it is sometimes necessary to conduct a careful analysis and to know civil instruments as a prosecutor, because you need to adapt your activity to instruments like simulation in the civil law, revocatory actions, which are known as Boolean action in some states, also in Romania, or possibility for these real estate contracts, for example. So it need to know also not only the criminal law. A key challenge is to know also civil law very well to adapt in this area.
Thanks very much, Edward. Yes, it's no fun to have to become an expert in trust or legal arrangement law when you're just trying to get your confiscation, but sometimes it is necessary. So maybe we can turn to a question that is likely to come up now that the FATF standards have been changed, and that I'll start maybe directing it towards our professor. What advice would you give to countries who are in the early stages of developing an extended confiscation regime, maybe talking to their legislature about it and considering some of the big picture elements?
The extended confiscation is meant as an instrument that should make the evidentiary proceeding easier. But I would say do not believe in the concept that the more far-going evidentiary facility is the better. Because the criminal judges take their decision based on the facts of the case when they are convinced that the evidence speaks for correctness of certain statement. And the courts, in particular those of higher instances, refer in their judgments to legal principles, like the principle of proportionality. And if the courts finds that the far-going evidentiary facilities do not let it apply extended confiscation in a reasoned way, it will not apply it. And we even observe the cases where the court of higher instance annulled the confiscation order of a court of lower instance. And just imagine what kind of confusion it may create in legal practice, in particular when, due to the wording of legal provisions, the required evidence has not been gathered by police officers or the prosecutor at the pre-stage of the trial. And what also comes to my mind when I think about the recommendations is estimate your capacities wisely. Well, extended confiscation requires the confiscatable assets in place, the trained staff that can find them and link them to criminal activity and secure them, as well as certain organizational facilities to store the relevant assets. So it needs time, financial resources, an adequate number of competent staff, and technical facilities of relevant organization to store the assets. Whereas some institutions, as we could see in the research, that where the courts may not have adequate facilities to store the virtual currency, for example. So applying extended confiscation in minor cases may result in wrong allocation of personal and financial resources, which are the practical issues. But there are also legal issues that should be kept in mind, in particular the court's finding of disproportionality between the predicate offense and the scope of infringement with defendant's property can result in court decision not to apply that kind of instrument.
That's really helpful. Thanks, Ella. I think that'll be really helpful for countries who do not yet have this tool to consider as they move forward. So now I think we'll look at the other side. So once countries have introduced this tool and they are using the tool effectively, how do we measure success and what metrics do we use? So I think there might be a misconception that it's just the sheer amount of assets recovered, but are there any other metrics that could be looked at in terms of how we measure success?
Yeah,
I'll maybe throw to Andrew on that. Yeah, go ahead, Andrew.
So yeah, I mean, there's obviously a number of ways you can measure success. In terms of the volume of cases you can include cases with low appeal rates, compensating victims. I think an important thing is to raise the public awareness of confiscation and the effectiveness of confiscation. And also, and I think this is an answer to one of the questions which has come up in the chat, which is success in revisiting historical orders. Somebody's raised the question, what happens if assets are identified at a later date? Now, in England and Wales, and I think one of the benefits of extended confiscation is that it will often increase the size of the benefit figure, so that it is, significantly greater than the known available assets. And within our system, we can, at any point in the future, if other assets are discovered, or if a defendant obtains assets in the future, we can revisit if there is a difference between our benefit figure and the available amount at the time the confiscation order was made. So I think that's another useful, consequence of extended confiscation.
Yeah, thanks, Andrew. That's music to the FATF's ears, because obviously statistics are really important, and not just for the sake of doing well on your next evaluation if you're a country, but also to set targets, expectations, and to measure your performance in a quantifiable way. So obviously keeping those statistics on the assets confiscated through this power, and as you mentioned, anything overturned is also really important. There's also, you raise a great point about publishing the successful cases of the use of extended confiscation. It really helps the public to see the law enforcement achievement, and it helps justify all of the expenses and the resources that are put into these cases in the first place, because they are not without cost. But if the public can perceive the benefit, then that really is the system, sort of justifying its existence and becoming sustainable, and hopefully sending the message that crime really doesn't pay. And that the government, in fact, has the tools to recover ill-gotten gains, even many years later. So, you may have acquired assets in, 2015 that you think are untouchable as a criminal, but in 2026, if you face a criminal case, there actually might be some ability to reach back. So hopefully it serves as a major deterrent. And if these cases can be well publicized, that'll definitely help. Perhaps we will turn to some of the other questions. I think we've probably provoked a lot of thought around these fundamental principles of domestic law, but what it essentially means is safeguarding rights and ensuring that the protections of law and due process are respected. And so I think, what are some examples of protections that have been put in place? And I think we'd like to turn to everybody, but maybe I'll turn to Ella first to see some of the safeguards that you've seen in your comparative research of these regimes.
Well, the is put clear in property conflict, and the legal origin of property is presumed. It's also the legal concept similar to the one by the German Constitution.
Ella, I'm sorry. I think we're having a little connection issue on this answer. We'll come back to you hopefully when it's sorted. But maybe any of the other panelists want to come in on some particular safeguards that have been introduced in your laws.
Yeah, so just from my point of view, just to reiterate from my presentation, within the Proceeds of Crime Act, there are basically layers of safeguards at each stage of the process as we go through and sort of decide whether it's an extended confiscation case, whether we can apply the assumptions, etc. But we have ultimately a sort of catch-all safeguard written into the Act, which is that the assumption should not be applied if they were considered to be unjust. And again, just to reiterate that those legislative safeguards have very recently been considered in the case of Colley at the ECHR and been found to be compliant with ECHR.
Perfect. Thanks for signposting that. I also remember the new video conferencing capacity in Edward's presentation, and of course, the notice that must go to interested third parties to potentially intervene in the case. Ella, I hope that fortunately we've gotten back in touch with you, and I'd love to hear what you were saying on this question before.
Well, I'm not sure how far you could hear me. I mentioned the constitutional restrictions that are available in Romanian constitution, for example, or interpreted out of the German constitution. But to keep it possibly easy, we elaborated the method. I mean the colleagues from 16 EU member states cooperating together on the research project on extended confiscation, we elaborated a method with the help of which each expert of national legal order can verify whether and in how far extended confiscation complies with fundamental rights. So it consists of 3 elements. It starts with the identification of the so-called vulnerable fields, so the fundamental rights and legal principles protecting them that are exposed to excessive interference when confiscation, in particular extended confiscation, is applied. So it would be right to property, privacy, various aspects of the fair trial, the principle of legality, legal specificity of its statute, as we already heard today, the non-retroactivity of more severe law, and so on. And in the second step, you try to identify the protection enhancing factors, so those that decrease the probability that fundamental rights will be under the excessive interference. So that would be, in case of extended confiscation, the need for clear indications of the connection of particular assets with criminal activity, the need to put the initial burden of allegation on the prosecutor, and to guarantee the defendant's right to remain silent unless the scope of eligible assets and their illicit character is substantiated, or the need to guarantee judicial discretion when assessing evidence and deciding on extended confiscation. And as a first step, we provided for some examples of best practices. So the legal provisions that work in some countries who have already applied extended confiscation, but they are not given to copy them, because that would be a kind of legal transplant that may not work well within the other legal systems, and every legal system must be internally consistent. So it's rather a kind of point of reference to show what works in other countries and think over how it could probably work in a concrete, specific legal order. Thank you.
Thanks, Ella. We're happy that you were able to get back with us to share that. And one final question, I think, as we are running out of time. I think it's been touched on a couple of times by different panelists. So anyone can feel free to jump in on this one. What are the challenges that may arise as to international cooperation linked to extended confiscation? Edward, I think you want to come in. Please go ahead.
Thank you. Yes, in the EU, we have a strong international cooperation under our EU laws, and the regulations are directly applied. So we have Regulation 1805. But are some consequences about these direct cooperations? Because as in European Union, we prosecutors and judges direct cooperate with other prosecutors and judges from the EU states. So in some cases, not all the judges or prosecutors know the cooperation, international cooperation. So I know we learn a lot from success cases, but there are in some of the greatest lessons we share about our not very well files, to say so. In some cases, I want to say some of the Romanian judge that didn't recognize extended confiscation order from France, again from France, because he rejudged the entire file of the confiscation, extended confiscation. So even if the court from Paris established that in that case the assets from Romania need to be extended confiscated, the Romanian judge didn't recognize it and establish that the extent confiscation is not incident in that file. And another obstacle is that the countries cannot appeal that sentence, and in that case, the Romanian prosecutor didn't appeal the sentences, and it was only in the first judgment. So it was a final sentence, which is not very. It wasn't a great case because, of course, French authorities came to the asset recovery office with a licensed magistrate, and we need to explain that it was a mistake indeed.
Yeah, thanks very much for that, for these war stories. But it really helps actually because in theory, cooperation on extended confiscation should be easier than, for example, maybe if it was NCBC or non-conviction based confiscation. And I think we say this because if you're in the extended confiscation realm, then you're dealing with a criminal prosecution, a criminal proceeding, and then you're in the realm of the mutual legal assistance treaties or the many different multilateral conventions that provide for assistance in criminal matters. And this is squarely a judgment that can come out of a criminal matter. And so there should be no questions about the applicability of the various treaties that countries can use to cooperate. I think where it gets probably more difficult, as you just explained, is when you're seeking to have enforcement of judgments in different countries. And the country that receives the request might look to the law on extended confiscation that they have and compare it to the one in the requesting state. And maybe if they don't match up, they might have some doubt about that. And I think at least in the FATF sort of realm, we would urge countries to sort of give that cooperation to the greatest extent possible, recognizing that the laws are not going to match. We've heard even today various different approaches to extended confiscation. But if it's a valid judgment under the law of the requesting state, if it's final and if it has complied with all the notions of due process, then hopefully the country that receives the request can really give it a good consideration, and hopefully their courts would recognize it. So I think that with this, we'll probably wrap up for the day and let people get to their lunch or their next meeting. But we really want to thank Andrew, Ella, Edward, the interpreters, and all the secretariat, and all the great support that we've had. We want to thank the attendees who have tuned in. I think we had over 1,200 people coming to this event. We hope that you found it enlightening and interesting. And thank you again for all of your questions that really teased out the important points. We encourage you to refer to the revised FATF standards that are available on the FATF's public website, and as mentioned earlier, the forthcoming guidance, which hopefully will be published in November and will definitely delve into extended confiscation. So we hope, Katie and I, that we've demystified it for you, at least a little bit, and answered the question, what is it? Which I would say was our #1 question in the chat. So thank you very much for tuning in, and I'll just flip it to Katie for a couple of closing remarks. And thank you again to all the presenters.
Yeah, thanks so much, everyone, especially to our panelists and those of you who joined online and submitted questions. Just to let you know, there will be 2 more webinars in this series, which will be announced in due course. One will occur between every FATF plenary. We'll be sending around a short satisfaction survey to everyone who attended on Zoom, so please look out for that in your inbox. We welcome any suggestions of topics to cover in the next 2 webinars as well. So if you have a burning question, a burning topic that you want to see demystified, please let us know. The webinar will also be made available on FATF's YouTube channel, both the English and the French versions. So if you found it helpful today, please don't hesitate to share the link with your colleagues and networks. And thank you, as Mary Beth said, to the interpreters for making this possible. And the last thing is that you can contact the FATF Secretariat at rtmg@fatf-gafi.org with any questions. And with that, thank you to everyone, and we'll let you get back to your day. So thank you so much for attending. Goodbye.